For that potential intervener, the court will serve in paper the notice of hearing, and the parties will serve their resistances or their responses to the motion to the potential intervener in paper. All the other people will get theirs electronically. This allows the case to progress forward, lets the EDMS system be used, but keeps someone who should not have access to confidential information out of it. Now, if in a dissolution case, let's say you have someone subpoenas a psychologist, and they want the psychologist to bring records of the opposing party to court, and the psychologist decides to file a motion to quash the subpoena. Okay, that would be a case where someone doesn't want to intervene, but they're filing in a confidential case. So the same sort of process applies. Serve that person in paper, but everybody else is going to get their information electronic. That keeps that person out and not seeing all the other confidential information or privileged information in that case, but allows them to file and still use the system. I guess before I talk about discovery, I want to talk about limited appearance. Under the rules of professional conduct, you're allowed to enter a limited appearance for, let's say, someone hires you just to deal with a temporary custody hearing in a dissolution case. That's a confidential case. How do you get in it? If you file a document, you're going to want to use this terminology, and Rule 16.322 talks about it. It's a limited appearance pursuant to our Rule of Professional Conduct 32.1.2 sub C. Okay, that will get you into the case and get you access to everything you need. When your contract with this person, this limited representation contract, is over, you've done the job that you contracted to do, you file a completion of limited appearance, and then you're going to be taken off that case and out of that case. So that's how you're going to be able to do that. Discovery. When you sign up and become a registered filer, you grant permission to your opponent to serve you by email discovery requests and to serve answers to discovery to you by email. Now, when you do that, when you file the request for discovery and you send it by email to your opponent, you also need to file just a notice that you filed that in the EDMS system. And what that does is, in case there is a problem with email on the other side, they're going to get that notice. They know to go check either the spam filter or call you up to make sure that everything stays on track. So it's a safety net, essentially, but still allows you to conduct your business electronically. As under the current rules, though, do not file your answers or your discovery information materials with the court. The court doesn't want them, and you probably don't want them to see all of it at that point anyway. Okay. Transcripts will be filed electronically. And here I'm not talking about court reporter notes, but this is when you order a transcript, let's say for an appeal, that transcript will be filed electronically. It will not be immediately available to the general public. It will only be available to the court and to the parties until there's been a period that allows for redaction to occur. Okay, and we're going to talk a little bit more about redaction of transcripts later. This next rule was actually very positively received by attorneys in the public comment area. Legal briefs and memorandums shall be electronically filed. Under the old rule of civil procedure, you weren't allowed to file most of this, and sometimes that created some sticky situations when you're trying to prove error preservation on appeal, and you'd have to go through a few extra hoops. This allows you to electronically file all this material now. Sealed documents. Okay, if you're filing a document or you're asking the court to seal a document, do not attach that document to your motion to seal. If you do, that document will be public in a public case. Right? So what you have to do is you file your motion to seal. If you need to, you'll electronically present the material that you want to be filed under seal to the court. Okay, so David Beckman is going to go through a little demo on some public or some e-filing, and he can show you how easy it is to make those selections. But now, if the document, if the court grants that motion, then the document will be sealed and filed. Once the document, once a court enters a protective order, if you're in a civil case and the judge said every time you talk about this manufacturing process and any documents you have to file, that can be sealed. Okay, so you don't need to go through that motion process again for the next document. You'll file the document, and there'll be a little box that says, we'll give the option of checking it if it needs to be confidential or filed under seal. And then in the comment section, you'll be required to put why it should be filed under seal. So you can say, this document is filed under seal pursuant to an order entered by the court on October 19th, 2010. And then you just keep referencing that order for any future filings containing that information. Now, if you forget and don't file, note that it's supposed to be sealed, it's going to go into the system as unsealed. I would think if you discover that later, you're going to have to move to get that sealed, so it can go back and try to capture that at a later date. System sealed documents don't require motions to seal, and there are certain documents that are filed routinely in court that are confidential, such as minutes of evidence, pre-sentence investigations, alcohol assessments, drug tests, that type of thing, and those will go in automatically as sealed. And when you log onto the system or this list, it's created and out there, will be readily available for you to look at if you're uncertain whether this is automatically sealed. Dissolution cases, and this is the family law area is one that really generated a lot of concern for storing electronic information in these cases. And so we just really want to make sure that people are aware dissolution cases are confidential until that final decree is entered, and then they're public. So anything you file, even though you're thinking, well, right, the case is confidential, at some point it's going to become public. So you still need to go through those steps of, should I ask for this to be sealed? Should I really be filing this? And ask yourself those questions. Exhibits. Exhibits are to be filed electronically as well and maintained in an electronic format. The rules are very vague on when conversion should happen. And that was done deliberately because different trials require different things. In a civil case, you may know exactly what's going to be submitted, and it's already been subject to discovery 10 different times, and you can have it converted and all ready to go, sitting in the system, ready before trial. In criminal cases, as a criminal defense attorney, you may be really not sure what you're going to be filing. Or you may not want the other side to see what you have at this point in time. So, and it may be difficult then to convert it and get it in there. Other situations, the courthouse or the jury room may not be set up or large enough to allow the jury to review these exhibits in electronic form. And so that's why it was left vague. So as you're going into trial, you'll need to talk to your judge about how you intend to present exhibits and what should happen with them after the trial. Original documents, and here we're talking about wills, mortgage documents, birth certificates, that type of thing. Where the law requires the filing of an original document, scan that document in, and then file the scanned version. The rules require you to maintain that original document for a minimum of 2 years or until the conclusion of the case or appeal, whichever is later. Now, your malpractice carrier, office practices, whatever, may dictate that you keep it longer than that, but the rules only require it for 2 years. Now, you keep that document, and if there's ever a question by the court or opposing counsel or party, and the court asks for you to bring it in, you must bring the original document in its original format to the court as soon as it's asked. There are some items that will not be filed electronically, and here we anticipate administrative records, except where the parties may agree to go ahead and go through the time or to scan it in, or it may or may not have protected information or confidential information. So there may be a point where parties say, let's get this in electronically. or the court orders otherwise. But for the most part, administrative